Mollie Fraser. This is an AP review, and today we are here to talk about Roe v. Wade and reproductive rights.
So to start off, this whole court case was about abortion. For those of you who don't know, an abortion is a medical procedure in which a fetus is removed from a pregnant woman's womb in order to terminate a pregnancy.
Now, before we get into the court case, let's take a step back and look at the history of the abortion debate.
Okay, so, until the mid-19th century in the United States, the way of determining if an abortion was legal or illegal fell under common law, which basically means regulations derived from custom and judicial decisions over time rather than actual legislative statutes. Under common law, abortion was not a crime until it was performed after the woman felt the fetal movement. When a woman did feel fetal movement, usually in about the second trimester, abortion was a crime. However, abortions were treated as misdemeanors, not serious felonies. This entire system was based on the Christian doctrine explaining when life was believed to begin. The American Medical Association, formed in 1847, believed that doctors should be held to a code of ethics, and a majority of its members, all prominent doctors in society, were horrified by the growing number of abortions by a middle-class married white woman who sought to control family size. So then, in 1857, the AMA began a campaign to criminalize abortion, except in cases where abortion would be necessary to save the mother's life. This campaign proved to be extremely successful by the beginning of the 20th century. By this time, every state had a statute criminalizing abortion, except when the termination of pregnancy was medically necessary to save the mother's life. As the 20th century progressed, these laws were revised to allow for abortions in cases of rape or incest, but abortion as a personal choice was not legal.
So you can probably guess a lot of women were not happy about this.
In response to criminal abortion bans, abortion rights became a goal of the women's rights movement during the mid-20th century. This abortion rights group became known as the pro-choice movement. The philosophy of abortion rights campaign was that if a woman could control their reproductive abilities without interference, they would become equal citizens to men, both legally and economically. We're going to get into the pro-choice versus pro-life aspect a little bit later.
Now into the actual Roe v. Wade court case.
So in 1970, Norma McCurvey sought for an abortion in Texas, which was, as you probably know, denied. At first she said she was raped, but could not prove it, eventually dropping that claim. McCurvey took her case to the court under the alias of Jane Roe, to keep her identity secret, kind of like Hannah Montana. She was suing Texas over the constitutionality, say that 3 times fast, of the abortion law. Roe was aided by women's rights activists and lawyers of the pro-choice movement who argued that Texas statute infringed upon the right of privacy granted to all citizens in the 14th Amendment of the Constitution. The case eventually made its way to the Supreme Court. On January 22, 1973, 7 out of the 9 justices agreed that the Texas state law was unconstitutional, declaring the right of privacy found in the 14th Amendment's concept of personal liberty and restrictions upon state action is broad enough to encompass a woman's decision whether or not to terminate a pregnancy. The court also stated that a fetus is not a person with rights granted in the Constitution, and that the court could not state the beginning of life as the moment of conception because there is no consensus on this philosophical question in the field of medicine. To grant state interest in health and protection of potential life, the Supreme Court acknowledged that a state may, but is not required to, ban abortion in the 3rd trimester of pregnancy because the fetus would be capable of life outside the womb. Nevertheless, a state must allow a 3rd trimester abortion to protect a mother's life, regardless of any ban placed on the 3rd trimester terminations. An expectant mother was now in the position to decide for herself whether to carry a fetus to full term or not.